Assalamu alaikum and welcome to the free legal advice show on British Muslim TV. My name is Riffat Hussain and I am your host for the next 30 minutes. The free legal advice show is an opportunity for you to present your legal questions and receive an answer to those from me. You can contact me by calling 01924 231 083 and speaking to me live on air. If you prefer not to do that, but would like to send your question through in a WhatsApp message, then please do so by sending your message to 07 585 835 150. Both of those numbers are displayed at the bottom of your screen. In terms of the questions that I can deal with, then you can ask me questions on a broad range of matters relating to English law. That is the jurisdiction that I practice in, and I should be able to address those for you today. Any advice that you do receive is based on the information that you present to me and will be in response to that information. Should you require a more detailed answer, then you are advised to seek independent legal advice based on your fullest circumstances to match your needs. I have already received some questions this evening, so thank you for sending those through, and I will proceed to read some of those out and address the queries. The first question we have is in relation to a professional it's in relation to a professional negligence claim or a medical negligence claim. The questioner asks, I have now been diagnosed with a serious illness. Let's bring that up entirely. So I have been diagnosed with an untreatable disease which could have been prevented if my GP provided me with the correct level of care. Can I sue? Now, in terms of the actual query, it would seem that our brother or sister has now been diagnosed with a serious illness, and they believe that this could have been prevented had they have received more appropriate medical care or care earlier by their GP. They are able to submit a complaint, and the best way to do this is first and foremost by contacting the GP practice and discussing their concerns with the GP practice directly. They are advised to request a copy of the practice's complaints policy, which will have written details of how complaints are dealt with and any timeframes that would apply to that registered complaint. If you feel that you do not want to contact the GP practice directly, then you may want to contact your local NHS service. In England, that would be NHS England. And they would again have a complaints process. They would also relate the complaint directly with the GP practice who can address that. Before I finish that answer, I will move on to a caller. Assalamu alaikum.
Wa alaikum salam. Sister, I just wanted to ask you a question surrounding child arrangement order.
Please go ahead, sister.
So basically, my husband and I were separated, and he took custody of my children through the child arrangement order. And the points of the order surround our supervised contact centres, and that's being done twice weekly. However, there's been a few breaches to the contact. He's taken the children out of the country to Pakistan for over 3 months. And he's now returned to the UK, but I think with the supervisor, so that's one breach. Another breach is that whilst he was in Pakistan, he didn't maintain the order, so I was supposed to get a few phone calls, and he usually would say there's no internet connection, but he managed to still, send messages. I'm still having supervised contact with my children, but I'd like it to be unsupervised, if you get what I mean. And I don't understand how to go through it, because I'm not eligible for legal aid, and my income's not really adequate.
So, sister, you raise a number of issues, and I just have a few clarification questions for you. So am I correct in understanding that the children are with your husband and you have the supervised contact?
Yes, that's correct.
Okay. And that supervised contact takes place in the UK?
Yes.
And the court order prevents your husband from taking the children overseas?
It says on the court order that he's allowed to take the children out of the country for up to a month, but he breached this. It was reported to the police. The police said, it's a child abduction. At that time, they declared it as a child abduction, but then he returned to the country back in May, and they've just dropped the case, to be honest.
So the police have dropped the case and nothing further has happened. And can I just ask, how long has this court order been in place?
Since October last year.
A child contact arrangement order is an order put in place by the family courts, mandating certain actions that a parent or parents are required to do or not to do. This sister explained that she was separated from her husband and they have children. The court has ordered that she has supervised contact with the children, and there are further conditions on this particular order. The sister feels that the order has been breached by her former husband, and that she is unable to access legal advice because of her income and her financial circumstances. Unfortunately, the lack of legal aid in many areas of law is a significant concern to many lawyers at the moment, because it does prevent many people from accessing the legal advice and assistance that they require. But addressing the sister's question, family law orders are very delicate issues, and usually there is confidentiality around those orders. So on a general basis, if the sister feels that the order has been breached, then the best place to go is to the court directly and make an application to the court for the order to be reviewed. Sister also mentioned that she's unable to access legal advice because of her financial circumstances. She may, however, be able to obtain free legal advice on a consultation basis. The majority of law firms will offer half an hour or 15 minutes free consultation at the start of a case. Alternatively, you may also be able to get some assistance from your local law centre or a citizens advice bureau. So those are options for you to pursue also, but failing that, you may wish to contact the court directly and seek some further guidance in terms of either varying the order if you feel that the terms now need to be changed, or raising a breach of the existing order. And I hope that answers your question, sister. I have received a number of other questions through WhatsApp, so I will proceed to address some of those as well. The first question is, I have arrived in the UK in 2011. I was granted refugee status. I got my indefinite leave to remain. Now my child, who previously was my dependent, is a British citizen. But I can't apply for British citizenship because I was advised that I had used verbal deception to gain entry into the United Kingdom, which was never true. I need advice. With regards to verbal deception, then the immigration rules do specify that there are circumstances in which the Home Office can either refuse an application or curtail an application if there are circumstances where deception has been used. Some refusals will be mandatory, so the Home Office must refuse an application if deception is proved. In other cases, there is a discretion where the Home Office may refuse an application. With regards to deception, and the circumstances in this particular question are unknown. If the alleged deception is entering the United Kingdom unlawfully, then there is a specific defence for asylum seekers, refugees who enter the United Kingdom, i.e. do so unlawfully, but then claim asylum at the first opportunity and then are granted or recognised as refugees. In that case, there is a specific defence that they should not be prosecuted, and the nationality guidance does also state that in those circumstances, that should not impact on a nationality application. So please do seek some further legal advice in relation to your specific circumstances, because further exploration as to what the verbal deception or the alleged verbal deception is and whether or not that does then prevent you for the time being from applying for citizenship as British. Moving on to the next question. So, assalamu alaikum wa alaikum assalam. If after getting indefinite leave to remain, my family leave the United Kingdom for 5 years, but in the 5 years they will visit the UK every year, can they apply for citizenship after staying in the UK for 12 months? In the 5th year, thank you. So with regards to the questioner, the family have indefinite leave to remain or have been granted indefinite leave to remain, but then do not wish to live in the United Kingdom on a permanent or regular basis. So the majority of time will be spent outside of the United Kingdom and sometime, a shorter period of time per year in the United Kingdom, with the exception of the final 12 months of those 5 years, where the family will then reside in the United Kingdom. Right, sister, if you continue watching, I will address your question after this short break that we are going into. Please continue to watch and send through any questions, and I will address those after this break. Assalamu alaikum and welcome to the Free Legal Advice Show. The question is, will that prevent a citizenship application? The answer would be yes. There are residence requirements as part of a nationality application or an application for naturalization, as it's known, which requires that you are not absent for certain periods of time from the United Kingdom. I believe those are, and you would need to double check these, but I believe it's 490 days in the first 4 years, and then no more than 290 days in the final 12 months. So if the majority of time is spent outside of the United Kingdom, then that would mean that you do not meet, and your family do not meet, the residence requirements for an application for naturalization. Moving on to the next question. I've been in the United Kingdom since 1998. I was given indefinite leave to remain as an Afghan political asylum seeker. I speak full English, but I can't read. Also, I have not been outside of the UK since 1998. I had a travel document, but I lost it a long time ago. I've been in a relationship, but this broke down, and I have a 17-year-old son. The questioner says that we are divorced, but I want to apply for citizenship. What should I do? Please help. If the brother has had, or sister even, I'm not entirely sure if it's a brother or sister asking the question, but if the questioner has been in the United Kingdom since 1998 and has had indefinite leave to remain since 1998, then on the face of it, you are eligible to apply for citizenship, as long as you do meet the requirements for naturalization. For naturalization, usually you would need to show that you have a residence of a period of 5 years. There are some requirements around the time that you have spent outside the UK, and also around suitability and criminal convictions. I hope that does answer your question. I have a caller, so I will move on to take the call. Assalamu alaikum. Hello, assalamu alaikum.
Oh, walaikum assalam, sister. I have a question regarding my immigration matter.
Yes, please, brother, go ahead.
Yes, so basically my first hearing was cancelled, and the judge has made like 6 weeks delay. He told me that your hearing is going to be in 6 weeks. So I got the hearing, but it's got like 2 months later. So what should I do to make the hearing as soon as possible?
Right. So your first hearing was adjourned. Is that correct?
Yes.
And do you know why your hearing was adjourned? Did you ask for it to be adjourned, or did the Home Office ask for it to be adjourned?
Yeah, the Home Office was. The Home Office were not ready. We are just launching some new public guidelines for people.
Right. So the Home Office asked for an adjournment, and the judge actually granted that and said the next hearing should be in approximately 6 weeks.
Yeah, they have asked for 6 weeks.
Right. And so was your question that you haven't yet received a new hearing date?
I did receive a new hearing, but it's like more 6 weeks. So basically, it's like 2.5 months later.
Yes.
Which was my first hearing was.
Right.
So the judge has made 6 weeks, but it's more than 6 weeks. It's like 12 weeks, something like that.
Yeah, I understand your question now, brother. Unfortunately, judges, when they grant adjournments and grant additional time, don't have access to the court listing. And that means that they cannot see availability for hearings. So what the judge will normally say is that I am granting an adjournment for a period of 6 weeks. And the next hearing should not be listed, or the next hearing should be listed, in fact, on or after a particular date. That will then go to the listings office, and the listings office will find an appropriate date and an appropriate available date, and then we'll list it. Is there a way of asking for it to be brought closer? You may fill in a form and write to the tribunal asking for your hearing to be expedited, giving reasons why.
Yeah, actually, my expedited request was for first hearing that was accepted.
Yes.
And they have accepted my for the reason they gave me the first hearing, that was because I did put expedited request, and they do accept that. So
yeah,
that was also the case on first hearing.
Yeah, so you may want to try that again, brother, but again, it would depend on the availability.
Another expedited request for the hearing, or is it going to be the same one?
No. If you want this hearing to be expedited as well, you would need to put in a fresh request. The old request would not be carried forward. So try that, and if there are slots available sooner, then you will be allocated a sooner date.
Okay, thank you very much, sister.
You're welcome. Thank you so much.
Thank you.
Thank you. So we are now moving on to another question which has been sent through WhatsApp. And if I just read this out, so I have been married with a British woman and lived in England for 4 years after that. Later on, she forced to cancel my visa, and I went back to my country. Now she's asking for a divorce. So what is the proper process to do and manage the legal process? It's unclear where, brother, you are based and which country, and whether you're asking about the divorce process in the United Kingdom. If that is the case, then you would contact your local county court and petition for divorce. They can advise you in relation to the correct forms and the fees that need to be filling in, as well as the timeframes that are involved in respect of that. You can find further information either through the court or on the Citizens Advice website. That is now bringing us towards the end of our session today. I thank everybody who has participated in this program by either calling in or sending through questions. There are a number of questions I've not got through. I will try and address those next time. Thank you for joining me. Assalamu alaikum wa rahmatullahi wa barakatuh.